Good morning, ma'am.
Good morning.
How are you?
Good. How are you?
I am wonderful. I'm just waiting for everyone else to show up.
That's usually how it is.
Good morning, Ms. Richards.
Good morning, Your Honor.
What are you here for, ma'am?
I have several PCCs.
Not with me. You have them with Judge Green this morning.
Oh, all right. Sorry about that. Thank you.
No worries. Have a good day.
You too.
Thank you.
Good morning.
I heard a voice, but I don't see a face. Who is that speaking out?
Good morning. This is Courtney Gibson. I'm the attorney for Linda Schmitzer, and I'm having an issue with my camera. It's when it's on, it's turning the entire app off. So some kind of
This
issue.
is the West Village Squires matter that's scheduled at 9 o'clock. Oh,
Yes,
no, 8:30, sorry.
it's
No,
8:30. Yes. Yes, Your Honor.
This is 223135 LT. This is West Village Estates versus Betty Ann Squires. May I have your appearances, please?
Corey Grand Mason, P 64392, appearing on behalf of the landlord in this matter.
Good morning, Courtney Gibson, P75806. I am appearing on behalf of Linda Schmitzer, who is the personal representative for the estate of Ms. Squires, who is deceased.
Thank you, ma'am. The last time we appeared, the parties requested an adjournment because the case was either in probate or going to be filed in probate, and that might address the outstanding issues. Where do we stand this morning, Ms. Gibson?
It has fully been filed, and I do have notice that it has been received by the probate court. We have not yet received a hearing date, but what I was hoping to propose was that, and this was always the intention, is that the full amount that is owed will be submitted through the estate, through the probate court as a creditor. So the apartments will be submitted as a creditor to ensure that they are paid. And then I'd like to just at least allow us to get the time to have the hearing date set so that my client is able to, because she's having difficulty managing both, obviously both properties, including her own residence where she does live.
So Ms. Schmitzer does not live at the subject property.
Right, correct, Your Honor. She has her own residence. This is a state property that was inherited when her mother passed. And so obviously she also inherited, until the probate case is resolved, she's having to pay both. And that's been difficult and undue, a burden. So, but it can be submitted as a creditor through the court. So, I mean, there's really no issue with them standing any chance of being unpaid.
Well,
Mr. Grant Mason?
Yes, I was just wondering what assets are actually in the estate to pay. Creditors can be notified in any probate matter, and if they either don't come forward or non-exempt funds are paid to the other members of the estate for whatever reason, creditors can be left behind even if they're listed with the court. So I don't know, Your Honor, at this time, other than maybe setting it out for another date, but I don't believe that this matter should be resolved by simply being listed as a creditor on a matrix for a probate estate is appropriate.
Well, Ms. Gibson, are you disputing that there's rent due and owing in the amount prayed for in plaintiff's complaint in this matter?
No, and that's what I wanted to kind of reassure counsel about. So, you can put notice out in a probate case and then creditors have an opportunity to respond. But if we actually submit this undisputed as a valid debt, that's different. That's actually going to be calculated into the way that the estate funds are allocated.
Well, respectfully, Ms. Gibson, the court's issue is if there's no dispute as to the rent that's due and owing, and this is a non-payment of rent case, there's no dispute, there's no tribal issue, and plaintiff is entitled to entry of a judgment. Why should this court not enter judgment in favor of plaintiff and against the estate this morning?
Again, I don't dispute that there is rent owed. Number one, what we do need to determine is certain dates with regards, but we don't deny that there obviously is rent owed, but we need to determine what the last payment was. So there are a few determinations so that we can determine the exact amount. And then what I'd like to do is just make sure that, because again, with the probate court, we need to preserve these assets. So if in fact the judgment is entered and then, I'd love some insight from counsel as to how that would be, how that would be handled. Would this asset be wasted? Because that's basically what we need to.
Well, hold on, Mr. Graham Mason, before you weigh in, that's a different conversation for a different day. This court is purely summary proceeding. It's an LT file summary proceeding. If you wish to have conversation with Mr. Graham Mason regarding the disposition of the property contained in the unit, that's a different conversation for you to have on a different day. My question to you a few minutes ago was, is there just any dispute as to the rent claim due and owing in the complaint? Is there a tribal issue? There's no reason for this court to adjourn this case again if there's no dispute. And if you're saying that you're not sure of the balance, I'm happy to put you in the breakout room with Mr. Graham Mason. I'm sure Ms. Samples has a ledger.
We can do that. I'd
And
like
your
to.
client is the personal rep who is not living in the unit. So I'm sorry, I cut you off, ma'am.
Oh, no, go ahead, Your Honor.
No, I was done. You started to talk while I was talking, so I didn't hear what you were trying to say.
Basically, just that we need to preserve the asset. What we need to do is, and what's typically done in this case, in a case like this, is that we need to determine, first of all, exactly what the amount owing is. And from what my understanding is, the protocol for this would be to simply to have the apartments listed as a creditor to ensure that they are paid once we determine that amount. But if there are any, because she doesn't live there, so an eviction process is not applicable. But the concern is the property being wasted. So in other words, the property being lost as a result of the lease ending, and that's what has to be prevented. So that's really what my main goal is.
Mr. Graham Mason?
I just know that I have an updated ledger amount as of yesterday, plus my costs that are owed in this landlord-tenant matter. $2,116.15 to retain possession, $164.57 in costs, fees, and attorneys' rights at this point, for a grand total of $2280.72. I understand that there might be some waste issues as far as this estate is concerned, but at this point in time, we're seeking possession of this item. Something can be worked out possibly regarding the unit itself, because it's a titled unit. And whether or not there can be a sale of that's arranged or whatnot is up to them. But at this point in time, we simply need to be able to, preserve the ability to do something with that property if necessary, if it were to, catch fire, if it were to flood, if there were something that could make it unsafe for the rest of the neighborhood. So that's where we're at this point. We understand that there's a probate proceeding going on, but we have certain rights regarding, our rents that are to be paid, and also to protecting the rest of the tenants.
Okay. I think my sound went out at the last part, but what I wanted to add is simply that the sale is pending. As soon as we're able to get that date, it would be a very short hearing where I would just appear and basically place on the record, all of the details with regards to the estate. And then once we had her letters of authority as the personal rep, she will be able to carry on with the sale and then make payment in terms of what's due owing.
I'm sorry, did you say when you receive the letters that she's
Yes.
the personal rep?
Yes, Your Honor. So when we
So
received
she's
the letters.
not, is she not already the personal rep?
Well, let me clarify.
If-
We have submitted to the court her application.
Your Honor, if it's contested, we shouldn't even be dealing with this at this point. I'm requesting a judgment at this time.
Mr. Graham Mason, when you don't cut me off, the next words out of my mouth while my hand was up in the air is, When we appeared last here on July the 27th, 2022, it was represented to this court that the daughter of the decedent defendant was already the personal rep. That not being the case, this court now having asked 3 times, was the amount claimed due and owing disputed? And the response was an unclear, but surely no, it's not disputed. There is no tribal issue. There remains no issue open in this court's perspective regarding this non-payment of rent case. That's how it was filed, as a non-payment of rent case. Plaintiff is entitled to entry of judgment as prayed, with rent to retain possession of $2,116.15, court costs of $164.57 for a total of $2,280.72. Plaintiff's office will submit a judgment reflecting those numbers to the court. If there is a conversation that the parties need to have regarding the disposition of the mobile home or the contents thereof, that's something between the two of you that no longer involves this court or this summary proceeding docket. Anything else, Mr. Graham Mason?
No, Your Honor, I apologize for cutting you off.
Don't apologize, sir. Zoom has that delay, and so I think we lose track of who's speaking or who. Anyway, anything else, Ms. Gibson?
Yes, Your Honor, I did just want to state that I wanted to make sure that it was not perceived as an intentional misrepresentation when that was placed on the record. But yes, that is correct. It has not been finalized as of yet. So once that is done, then she will be the official personal rep. But she, there's no objection, to her petition.
I understand. Mr. Graham Mason, are you going to have the standard 10 days in the judgment, or are you allowing Ms. Gibson more time to get her ducks in a row?
Ms. Samples is here. She can use her own judgment past the 10 days, but our policy is to get what is allowed by the law, Your Honor. 10 days.
Thank you, sir. That concludes this matter. Email your judgment over. I'll get it signed and get it out to the parties. Everyone have a good day.
Thank you.
Your Honor.
You too, Your Honor.
Good morning, Sandra.
Good morning.
How are you, ma'am?
Not bad. How are you this morning?
I'm wonderful. I have not seen Mr. Davis as of yet. The attorney, Mr. Katz, for the plaintiff has checked in. I have your last name as Maloney. Is that correct?
That is correct.
Thank you. My policy is 15 minutes after the scheduled start time, so long as Mr. Davis is here by 9:15. Other than that, we'll enter a default. He's been pretty prompt in all of our prior hearings.
Okay.
Morning, Your Honor.
Good morning, Mr. Katz. How are you, sir?
Good. Trying to log in on another Zoom and I can't seem to get my other computer working, but I've got one case with you, correct?
Correct. We have
And I
Mr.
think this
Davis.
is, yeah, I think this was the individual that was deaf.
And we have an interpreter here. That's Ms. Maloney.
Oh, okay,
Hello.
perfect.
Good morning.
Good morning. Should I speak to the interpreter or wait till Mr. Brown, Mr. Brown is it? Yeah, Curtis Brown.
Curtis.
Yeah.
Davis,
Okay,
Mr. Davis, I'm sorry. You
Davis,
should
I'm
wait for
sorry.
Mr. Davis, unless
Okay.
you have an update for me that would dispense with this
Well, the
matter.
update is he made a payment. I think his balance is like $1,000 as of today. So let's see what he has to say as far as
Thank you.
that. Okay. All right. I'll put you on mute and shut the video for a second.
Thank you.
Lights
The
go off
energy
if you don't move.
efficiency. They do.
So you're in the new building, right?
We are. We've been here since last May.
So how is the new building? It's too bad no one gets to see it.
Mr. Katz, we are open to the public. There are people out in the hallway right now. I'll start
Not
setting
my
all your
public.
cases live. How's that?
I'll stay where I'm at. I'm okay.
No, it's beautiful. They did a great job. There's a lot of natural light, so even when the overheads go off, it's not bad in here. I just saw it the light shutting off back in the gallery, and I knew it was coming.
I'm gonna miss the old courtroom though.
No, you'll like this one better, trust me.
I know, but there's so many fond memories and so many, well, I won't
So
say
many
anything.
what? The carpet that was older than both of us? Yeah, that was fun.
Yeah, smells that I'll never forget.
That's what we give in the 34th district. We give memories. Ms.
Yes,
Maloney, we
yes.
give memories, trust me. Oh, but Mr. Katz, have you really not been here yet?
No, I got to watch it getting constructed. It must have been it was almost ready to go. I think April or May, they were supposed to be completed, and then COVID comes, right?
Right.
Yeah, so I'll
It
get
is.
the virtual tour at some point.
Yeah, I can't do it justice from here.
Yeah,
You-
no,
you
it
should
looks
come.
nice from there. I mean, it's a new desk actually, so that's nice.
Well, same chair. This is the chair from
All right, it's a nice
the
chair
whole
though.
building, but same chair, same flag. But you should come over. They did a really good job. There are 4 hearings room, well, 3 courtrooms in a hearings room,
Uh-huh.
2 stories.
Yeah, I mean, it
private
looked
rooms
nice when
for
it was going up. If the
attorneys.
state court administration could give me a little break on my hearings and the two hearing process, then maybe I'll have time to actually stop by.
You know what? That's what I'll do. Next time I adjourn one of your cases, I'll schedule you live.
Do it in person? Thanks.
Yeah.
I will. I'm happy to do it.
No, it's okay. It's okay. I'd rather just do it on my own volition.
We have about 3 more minutes. Let me see. I don't know if I, oh,
Oh,
that's a better
very
shot.
nice. Look
Oh,
at
that's
that.
beautiful.
We've
Wow.
used the jury box one time in this courtroom. We
Wow, that's
have
a nice-
holding
that's a nice
cells,
setup.
next to the courtrooms now, so no more people in custody in the hallway.
Oh, all right. Reduces the risks.
Correct. Our security staff are very happy about that.
Oh, I bet.
You still have lockers right when you walk in that I could leave my phone?
No,
That was actually a good idea. I actually liked that the court had that. That was very considerate of the people who couldn't come in with the phone and didn't have to go back into their cars. So it was nice.
but things change and people are allowed to have their phones in now.
Yeah, that makes sense.
That
So,
we have to remind to turn off the ringer. We had some guy with like a Donald Duck sound, an attorney in the middle of a preliminary exam. His Donald Duck phone start ringing. Yeah,
See,
that
now
was fun.
that's the part I miss about in-person hearings.
person?
Those anomalies that might not be so anomalous.
But we spend all this time on Zoom, and then when people come in, it takes me a minute because in the box, you can't tell how tall somebody really is, but they come in and you're like, oh, wow, interesting. I am concerned that Mr. Davis is not here. He has been pretty prompt. I'm checking the ROA. There's been no updated phone call or indication from him that he was not available.
I'm guessing he came in with with an amount that was pretty close to his balance when we were in court last time, but
Well,
now,
Mr. Katz, do you mind double checking? Because when we were here last time, he was gonna pay $1,200 by July 29th, and then the balance he thought he would pay the following week or 10 days after or something. If you don't mind checking with your client real quick.
well, I
if we're gonna
did. He
dismiss the
paid
case.
$1,600. He just paid $1,600 like a couple days ago. So that was his first payment. So he had a balance of $2,600. And then just paid $1,600. But let me call them right now and let me see if I can get a hold of
Thanks.
them. Just to
As
make
soon as
sure.
you come back, I'll call the case.
Okay, no problem.
Thank you.
I mean, if you want, worst comes to worst, we can adjourn it till the 30th. I think I'm in front of you on the at 9:15 on the 30th, but let me see what happens.
But I'm not gonna bring the interpreter back, so that's why I want
Yeah,
you to
that
check
that
now
makes
for me,
sense. Okay,
please.
let me see what happens.
Thank you. Are you done with your docket? I have one case. If you don't mind waiting for a moment. Okay. This is 222450 LT. This is Barrington versus Curtis Davis. May I have your appearance, please, sir?
Good morning, Your Honor. Sidney Kiatz on behalf of the plaintiff.
Also
San-
present in the courtroom. I'm sorry, go ahead, ma'am.
Sandra Maloney, sign language interpreter.
Thank you. Today was the day and time set for the adjourned hearing in this matter. And as much as Mr. Davis is hearing impaired, the court secured an interpreter so that we might resolve this non-payment of rent case. Case was scheduled at 9 o'clock. It's now 9:16 by this court's clock. Mr. Davis has failed to appear. This court's policy is 15 minutes after the scheduled start time. The court had some conversation with Mr. Katz regarding the balance in this matter, asked him to confirm it before we proceed to default in this matter. Mr. Katz, your update, sir.
Your Honor, I did try to reach out to my client, but I think their office is closed. What I'm requesting that I do at this point is enter in a default judgment. When I do reach my client, I will see if the balance is still what I'm claiming. And if it has been paid, I will submit a dismissal instead. I'm guessing I could do that before I submit the judgment to the court and wait a couple hours until that time. Does that work for the
The rent
court?
to retain possession, sir, I'm
Is
sorry.
835, 165 of cost for a total of $1,000. Requesting a default judgment in that amount with the writ to be issued after August the 29th.
Thank you, Mr. Katz. Based on Mr. Davis's failure to appear, default judgment will enter with rent to retain, $835, $165 in costs. Total default judgment, $1,000 with writ date of August 29th, 2022. Claims office to submit that judgment electronically. Anything else, Mr. Katz?
No, Your Honor, it might be a couple hours until I get a hold of my client. I'll wait till then to either submit the judgment or the dismissal.
Thank you, sir.
you.
Anything else, Ms. Maloney?
Nothing else.
Thank
Fantastic.
you
I
for
wish I
logging
could.
on.
I gotta learn sign language so I could actually figure out
I
what you were
took it for a
saying.
year in college, but it's been a long time.
Oh, good
I
for
could
you.
barely speak English. It's okay.
Yeah.
Thank you so much. You both have a
Thank you.
wonderful
Have a good
day.
day.
Thank you. You have a great day.